So now case law says that it's up.
Excuse me. Would you identify yourself?
I'm Judge Mike Kelly, Family Court Judge, 11th District Family Court, Mount County.
Okay. All right, so we're going to have this Jeopardy thing here going. So case law, so if there's an issue of parenting that comes up during or after the divorce, those two are the same, right? I would assume because this law is sort of certifying these are the parents, and that's the way it's going to be.
Right.
So if that issue comes up during the divorce or after the divorce, what happens? And what does the law say to this end?
I'll give you the reality-based
Okay.
answer. Sometimes it can be a little different. Somebody comes
Actually, I want to know exactly. Actually, I'd rather have the case law. That's what I want to
case law requires employment authority.
If a request is made.
The question is whether or not.
I mean, if there's a question about paternity, the court requires an appointment of guardian.
Appointment of guardian ad litem. The guardian ad litem reports back to the court on two issues.
Mm-hmm.
Is testing in the best interest of the child, number one. And then two, if testing is in the best interest of the child, and testing is done, should it change in the father, is that in the best interest of the court?
And are those answered at the same time? Or if the answer to one is yes, do they go to the second question?
Well, they are not answered at the same time because of the intervention of the tests. Testing is in the best interest of the child, and the test comes back that dad is, in fact, the biological father. It should go.
Right.
It's when it comes back and says that dad is not the biological father. But should he still be considered the father for purposes of law?
Okay. And what's the reality base of what happens in this situation?
If it's a very young child and the parties have been separated, we'll almost always use testing, such as if the child is 6 months to, let's say, a year old, has not really had an opportunity to recognize a parent, a dad, biologically with a long-term history of benefitation and chewing them up. 6 young child, dad says, this is not my child. We were separated at the time. I almost always give testing without the appointment of a guardian ad litem. And in almost every case, when the child comes back, and if he's not the dad, there's very little context. He's not the dad. We amend the birth certificate and consider no more child support.
Okay. And so in those other cases where you find out that the father on the birth certificate is not the dad, what kinds of scenarios do we have? And what?
Well, we have two. I've seen them both ways. One is where mom insists that he still be considered the dad.
Mm-hmm.
And that he is, how would it be phrased, this is the only dad this child has ever known. On the other hand, and I just had this case last week, dad asked that he be considered dad. Because this is I'm the only dad this child has ever known. Even though
So did dad ask for testing?
Mom had asked for tests.
So
dad didn't want the test, finally agreed to the test, and the test came back, he's not the dad.
And this was in a divorce situation?
This was in a divorce situation, and the way it was resolved is that the parties all agreed that dad would be the psychological dad. He wanted to pay child support, had no problem with it, and he was awarded time with the child by agreement of the parties.
Well, let's say the other scenario where you find out that the father on the birth certificate is not the dad, and he's horrified that the secret has been kept, and he wants to terminate the relationship because he's felt that he's been, I don't know what the right word is, but you know what I mean. What happens then?
Then the court
What if the child is 12 and the dad has been acting as right?
And he wants to sort of disestablish himself as the father. There, we appoint the guardian, assign the guardian, reports to the court. Many different issues to take into account. Psychological impact on the child, whether or not there's somebody else step into that role. Is the real father, the biological father, clear at all? Now, I've actually had that instance where the third party knew all along that he was the dad. And they spent some time with the child, and there again, by sitting down with all the parties, we reached an agreement that the married father was disestablished and that the natural father stepped in his place. There was no child support. The birth certificates were changed. But those are very difficult issues, and that's when we, almost all of those cases, try to use a skilled mediator to arrive at the best interest of the child. And I've never had a case fail.
With the mediator?
Not on that issue. I've never had a case appeal, never gone to the Supreme Court. We try to sit down and do what makes sense for this child and these parties.
Have you had occasions when the child, you have discretion to order the test or not order the test, the way it is right now. Have you had occasions where you decided it was not in the best interest of the child to order the test?
No.
Do you think that that's very common, judges would refuse to order the test?
I have heard of it. My own position, and I announce this to the parties and ask them to consider it, is right now we have independent reasons for knowing who's the dad. We have medical and health reasons. We need to know the genetic makeup of that child. That in and of itself, to me, it means erring on the side of doing the test. Whether we're going to undo the fatherhood is a completely separate little question. I don't recall a single time that I rejected a test. And usually the tests are given over an objection from mom. I probably had less than 5 times in 8 years.
Mm-hmm. Although I suppose those 5 times are particularly probably brain dead. Those are very highly contested, very emotional situations.
And all of them resolved.
Okay. Well, good. All right. Do you think that there would be harm if, given that you have every single time ordered, and let me go back a second. I know I had something else I wanted to ask. Are there situations when you have been requested to do a test that you didn't think the information was necessarily very reliable? Is there a spectrum of information about why you want to do a test from one, which is like, I got an anonymous phone call to, I have somebody I know that I trust told me that I was not the father of the child, and I'm,
Yes.
But you still always have ordered it.
I have, but here's whether or not we get to that point is sometimes based on the answer to this question. Do you have enough doubt that you are willing to post $127 for the cost of the study? Because if you merely are curious or want to hurt the other side, you're not going to do that on the state's dime. And if you, in fact, are not the father, the state will reimburse you $127. So, of course, if you are, and you know you are now.
I've seen a lot of parents that would pay a lot of money to punish the other party.
Well,
and I'm not saying that, and 127 would be, give them pleasure.
I don't know what pleasure it gets when we come back and we read the announcement and the party who said it was the dad all along is sort of sitting there with a big smile. Now, for the party is frivolous, who wants to just take a quick slap. $127 does pose a dilemma. Now, somebody can say, I don't have it, can I pay it? Oh, sure, you can set it up so you can afford it. But I have found that really begins to separate the majority of the frivolous allegations versus there's serious doubt.
Okay. So back to my other question is there a reason to not say that if people that pony up with their $127 for whatever reason, that they should have the right to do that? Is there a real strong reason? Because I guess one thing it seems to me is if there is, especially if it is not true, that the person is the father of the child, we're preserving a lie or a fraud, possibly. Is there reason to continue to allow the discretion?
Well,
Or is there a reason to modify the discretion and make it, more of a rebuttable presumption that it should be left? Something like that, to add maybe some protection if you really think that it's being done for bad motive, making it.
well, the case law clearly not from the Supreme Court would say that the first question you have to raise is in the best interest of the child. And again, that is the type of situation where somebody's been a long-term parent, where the child is family. I think the family is great.
Well, but isn't it also, one of the things I've been thinking about here is, if you have, whether or not you give the test, if somebody's going around saying, I don't think you're my dad, or I don't think you're my child, isn't that going to happen? And we could resolve this. If that kind of discussion is going on in the family, is that not terrible for the child?
It is terrible for the child.
And that's, the question that you're asking, is it good or not good for the child? To me, another question is, if this question is being asked by different parents, isn't there a likelihood that that information is going to get back to a 12 or 13 or 14-year-old?
Mm-hmm.
And so the question isn't only, should we give a test, and but is it in the best interest of the child to have this doubt being raised? Don't you think that that's out there too?
Well, I absolutely agree with you. You're talking to somebody who gives the test all the time.
Right. Well,
I've never found it to be so harmful to the child that we should deprive the parties of that essential information.
couldn't that be essential? Well, what you're saying is you think it's essential information to the child for medical reasons.
To the child, to the parents, and I'm going to override any objection, allow the test. Then we'll deal with the question about the disestablishment of paternity. I think we need to test.
Mm-hmm. Well, the way, right now, in code, it does not say that you're allowed to get a test. So as far as what is generally available in terms of what people in the public might know, they think that, and that's what I thought the rule was, is that you couldn't get a test. Case law is another thing. Would there be any disadvantage in putting into case law or putting into the code that you have a right to get the test, so long as you pony up the $127? Would there be a problem with that?
Now, I would just want to go back over the case law and see whether or not any of the decisions, I don't think they did, just to ensure myself rested on a constitutional principle, which would override the case law.
Okay, thank you very much. Thank you.
Thank you. Well, some of us have 4 o'clock meetings, and I did want to, if you have a short question, but I did want the judge to talk about this other bill. I mean, not talk about the bill, but answer questions about the process. Well, you want to...
Well, the only thing I was going to ask if Ms. Tackett had anything to add to that.
The only thing I was going to say in this current version of 4002, what it does here is it says that this person can move to, to have paternity testing if they haven't done one of many things here, and one has acknowledged that they're the father in a sworn affidavit. So this is more limiting than the case law. This statute is.
Or the proposed bill.
The proposed right bill is more limited.
Thanks.
Thank you.